Sam in Enfield. Sam, good evening.
Good evening. Hi, Daniel. Thank you for taking my call.
How can I help?
I hired the services of a structural engineer to do some calculations and drawings for me. I paid him up front, and he did the calculations and the drawings, but they were handwritten, and I couldn't understand his writing. I showed it to the builder. The builder couldn't understand his handwriting. I explained that to him, and I just asked him if he could redo it or just, retype out the wording of what he's written and the 5 calculations for the steels and what have you. He refused to do that and requested more payment. We kind of went backwards and forwards. In the end, I threatened to sue him and what have you. He then did the calculations, but by that time I said I don't want to use his services because breakdown in communication, and I've lost faith and trust in him. Can I take him to court to sue him for the money that I paid him for the work that he was meant to do, didn't do? It doesn't sort of just end on that, because the builders need to liaise with him and I need to liaise with him, and so the building control. Where do I stand?
What a mess, Sam.
Yes, I know.
I don't think there's an easy answer to this one. So, first of all, you've got to show that he's in breach of contract.
Right. Okay.
Is he in breach of contract by having messy handwriting? Goodness knows. He's got to be able to show the plans. He's got to be able to display the drawings and the calculations in a way that someone else can understand. You say you couldn't read it, the builder couldn't read it. That's pretty good evidence that it's hard to read, but would a judge be able to read it? Would another builder be able to read it? Don't know. Let's assume that it's genuinely completely illegible.
Yeah.
It is totally unreasonable of him to demand more money to rewrite it out if it is totally illegible. Is there a reason why the two of you couldn't sit down and he could just tell you what it said and you could write it out?
I'm not technically minded in that way. It wasn't just he wouldn't do that. He said he wanted to speak to the builder for the builder to do that, but then also there was the company that was doing the steels. They couldn't understand his handwriting.
Okay.
So he was saying, get them to call me. Then there was building control. He wanted them to call him. So
which is completely ridiculous. You need the drawings to be comprehensible.
He after sort of threatening him to take him to court, he typed it out. In the end, it was just, it could have been done within minutes. He typed it out, sent it, and said, "That's my obligation fulfilled." Basically, end communications. But
so sorry, was he saying he didn't want to carry on doing the rest of the work?
Yes, correct. So what he's saying is that I paid for the drawing, for the technical drawings and the calculations. That's it. He's done that. He supplied it. But the not just one builder. I spoke to a couple of builders to get some quotes, and even building regs were asking, why has he done this? We need this clarified as to why he's done this, why he's done it this way, and he won't communicate with me. What do I do?
Right, so he's the one that's finished the contract, not you, but he's under no legal obligation to continue and enter into a new contract with you to do further works. The issue, and I don't know the answer to this, Sam, I'm just posing the question aloud. The issue is whether there's, I'm going to use some legalese here, whether there's an implied term in your contract with him to do the initial drawings that he would liaise with building regs inspectors and builders and so on subsequently and have a reasonable degree of liaising with them. My instinctive answer to that is yes. Yes, he should. He's not allowed to just hang up his tools and not do anything afterwards. And if that's right, you would have a claim for any additional costs that you incur in getting another structural engineer to do a lot of the same work again. Yeah. How much money did you pay him?
£600.
Oh, my... Sam... Don't worry about it. Don't sue on a difficult case over such a small amount of money.
Right. Okay.
Seriously.
Okay.
You didn't? Did you pay by credit card by any chance?
Debit card.
Debit card. So you might want to put in a chargeback claim with your bank, but he's going to say, well, I did what I was meant to do, and the bank's probably going to side with him on this one because it's too complex for them to say, no, there's a clear breach of contract here. You've got an argument, but I'd put it no higher than that, Sam, and for £600, I would not litigate over this.
Okay.
Just take the hit.